Theophilus Smith. Your case.
Ash Phelps for the people.
Third report, Mary. Theophilus Smith.
Yes,
I've got you, Mr. Smith. I'm waiting on your attorney. Whose case?
Yeah, who is the attorney?
Mr. Brown's case, Your Honor.
Yeah, I would like to fire my attorney immediately. I like to fire my attorney, fire all representation.
All right. We'll get to that in a minute. Maybe he knows already, which is why he's in here. Sorry about that.
Okay. Ron Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Smith.
So that you're aware, you weren't in the courtroom. Mr. Smith did identify himself, so I'm not going to ask him to do that again. And he indicates that he wants to fire all his representation.
I understand, Your Honor. Has the court received an updated competency report?
October 22nd.
Yeah, I speak on that because I'm representing myself.
The report, the last report I have is from July, but it was
no, the only report
that we received on October 22nd. I don't know that. Okay, Mr. Smith, we both can't talk. Okay, I'll hear you, but we both can't talk right now. All right.
We have.
I don't know if that. So to finish that thought, I don't know that this is an updated report because it's dated July.
Right.
Maybe you have a 2-week adjournment so we can try to figure out what's going on.
2 weeks.
So I will say.
You don't want more? No, go ahead.
I will say this for the record. Your Honor, I believe the last report has indicated that Mr. Smith has not yet gained competency. So I'd ask the court to not fire me from his representation. To not fire me from.
No, I'm not. Yeah.
Thank you.
You already knew what my decision on that was going to be. What I'm going to do, Mr. Smith, is I'm adjourning your competency hearing. We need to get more information, and then I can act on whatever you may want me to act on. But yes, Mr. Smith, what do you want to say?
I would like to fire Lauren Brown if I need to get representation. Me and my mom, we got plenty of money. We can hire somebody to represent. I will no longer want a public defender like him. I do not want him. He hasn't been to see me. He don't know none of my angles. He don't know anything. And first of all, I do not need a competency exam for a $1 Prohibited Fire Act case.
Well,
the case is arson. It's only a case that I burned the box. It was only a $1 box that got prohibited. It was a prohibited fire act. The smallest.
Okay,
I so get a competency exam for that.
Okay, so Mr. Smith, I can't do anything till I get that report.
Well, can I speak on bond then? So because I think it's ridiculous.
Mr. Smith, since I can't do anything, I'm not going to do anything. I understand what you're requesting. I get all of that, but I need an updated report to try to figure all of that out.
But the thing about it is, I never wanted a competency exam. These I know you don't. These lawyers are doing what they want to do. Okay. Nobody's communicating with me, and they're doing what they want to do. I wanted to speak on bond. Ain't nobody talk about when I'm getting out of this place because I'm being.
Well, you're not helping yourself with regard to that argument. Yeah, that close that. So I'll adjourn this to November 13th. Why not? 2025, 9 a.m. That'll be a good week. Bond at this point will continue. Thank you. Thank you, Mr. Smith. We'll see you in a couple weeks.
Thank you.
Assistant Senator Liba for Mr. Burnett. Mr. Barnett, could you state your name, sir?
Robert Michael Barnett.
And Your Honor, we're going to be requesting an adjournment. Additionally, would like to address bond.
Probable cause conference will be adjourned November 6, 2025, 9 a.m. as to bond.
Thank you. With regard to bond, and Ms. Barnett is currently being held on two matters. Based on my review of the police reports, it appears that those two matters arise out of the same incident. I don't know if the prosecution would disagree as to that. So I'd be asking for one of those bonds to be reduced to a personal bond if possible. Additionally, I did discuss the prior.
Why would that? I don't follow what you're saying. Why would that say there should be a personal bond?
Your Honor, can we approach for a moment?
No, I don't need your approach. I just don't understand that.
Your Honor, so two of the offenses appear to be one incident that were inadvertently charged as duplicates. So I'd be requesting for one of those bonds.
So you're saying that one's a duplicate,
Yes.
so he doesn't really have that case. Do people agree on that? Or?
This is the first I've heard, Your Honor. Mr. Hingo and I did not have a chance to discuss that before the matter was called. I don't know. I would have to double check. I'm not 100% sure. I would indicate, though, that at the time that the possession case got picked up, which is 25F55793, he was in bench warrant status for the receiving, concealing stolen motor vehicle. So I would be opposed to any change of thought as he previously failed to appear on the fingerprint case.
And I did want to address the previous failure to appear.
Okay, I see that it looks like the case ending in 1406 and the case ending in 965. I don't know if they are or if there were two motor vehicles, but they, on the face of it, could be.
They could be.
But I'm not going to have. One says a pickup truck, the other specifies a Ford F-250. But I don't know that they're the same. Mr. Lebo, you had to talk to counsel about that. They can't be surprised by that.
Yes, sir. And I did send an email. My understanding is that they may have reviewed that, but I believe that the email may have gone to a different prosecutor.
Okay. All right. What's the other explanation regarding?
With regard to failure to appear, Ms. Barnett has admitted to me that he was suffering from fairly severe substance use problem at the time. He tells me that he has since completed treatment at Share House, and he attends meetings on a bi-weekly basis, or rather a twice-a-week basis. Says he is very eager to have an opportunity to be released to prove to the court that he will be showing up in the future, and we would have no objection to a tether.
We do agree with you because we'll get one dismissed. They do agree with you.
Okay. All right. So there'd be only two cases, but all right.
He was still in bench warrant status at the time, so I would be opposed to any change of bond.
All right. Because of that, motion for bond reduction is denied. Bond will continue on these matters.
Thank you.
All right. Thank you.